So you gotta let me know, should Wilson stay or should they go? Hey, I'm Andrei Mincov, the founder of Trademark Factory, and in this video I'm going to share my thoughts about yet another trademarking screw-up. This time around, it's the band The Clash going after tennis manufacturer Wilson over the use of the brand Clash. All right, I'll start with reading the article, as always, and you can find the link in the description below. The Clash sues Wilson over its Clash tennis rackets. Copyright infringement lawsuits in the music industry have been all the rage lately. Now it's time for a trademark challenge. That's a good subheadline. Late last week, The Clash filed suit claiming theft of its trademark. The band has filed a complaint in Los Angeles Superior Court against Wilson Sporting Goods, alleging that the company was infringing on the band's trademark by introducing a line of tennis rackets called Clash. Of course, the word Clash has existed long before the band or the tennis racket, for that matter. So how can anyone own a word in the dictionary? Well, that's the question we get asked all the time, and I can't even count the number of times I've answered this question, including in videos, but let's keep reading. Turns out it's a bit more complicated than that. The lawsuit contends that The Clash have long had a presence in the tennis industry. The band noted that it has licensed its music to a number of major tennis events, including Wimbledon. It has also licensed a Clash branded line of tennis sneakers that were made by Converse. All right, so first of all, let me address the dictionary thing again. A trademark doesn't mean you own the word. A trademark doesn't mean you own the image. A trademark doesn't mean you own the phrase. A trademark means that you are the only company or the only person who can lawfully, without asking anyone else's permission, use that word, that phrase, or that image in connection with selling products and services for which you registered your trademark. So the list of goods and services, of products, of the services that your trademark covers is extremely important in your ability to enforce your trademark against other people or against other companies. And this is exactly what the dispute here is going to be about. So I'll walk you through the trademark applications. I'm going to show you exactly what's happening there. But first, let's keep reading. Dorissimo Limited, which is the UK-based company that owns the Clash's trademark, insists that Wilson's new tennis rackets are employing the band's trademark without permission. The overlap will confuse consumers into thinking that the rackets were endorsed by the band, according to the complaint. Really. Quite honestly, I don't think this is a very realistic assessment, given that the band has not been, how do I put it, at the top of the charts lately. And very few people probably will draw that mental link between the tennis rackets and the band, or endorsement by the band. And so what they're claiming is that they've licensed its music to a number of major tennis events. So Wimbledon may have played that song that I started this video with, you know, Should I Stay or Should I Go? Their major hit, or maybe some other music. But just because they licensed the use of the music at the event doesn't mean that now the name of the band associates with tennis rackets. It just doesn't make any sense at all. Similarly, so they've licensed the Clash branded line of tennis sneakers by Converse, but again, is this enough? Is this close enough to tennis rackets? I think it's a major stretch. It's like a major stretch. But let's keep going. Complicating matters is the fact that Wilson which has been selling Clash tennis rackets since February of this year, currently owns the US trademark for the word Clash as it relates to tennis rackets, covers of tennis rackets, and sport bags. So Wilson actually trademarked their brand, which is why the band The Clash is not going after Wilson's trademark within the Trademarks Office system and in opposition proceedings. They missed the opposition proceedings. So Wilson registered the trademark with no issues. And now the only way for the band to do something about it is to sue Wilson. So let's keep going. Because of this, Durissimo wants the California court to cancel Wilson's trademark, which they say infringes on their own US trademark, which covers merchandise, apparel, as well as music productions. In addition to the cancellation of the trademark, Durissimo is seeking damages from Wilson for at least $3 million and all profit that Wilson has derived from its Clash products. They also want Wilson to destroy its inventory of goods containing the Clash label, and they want a permanent injunction against Wilson, which would prevent the company from ever again using the word Clash on any of its products. So far, Wilson has yet to issue a comment on the matter. Probably they're just trying to figure out a polite way of saying, ain't gonna happen, right? The Clash, who enjoyed immense success in the 70s and 80s, disbanded in 1986, and more than 30 years later, classics like Should I Stay or Should I Go and Rock the Casbah. I have no fucking clue what the fuck it is. More than 30 years later, classics like Should I Stay or Should I Go and Rock the Casbah are still getting heavy plays. All right, so the music may be getting heavy plays, but their chances of winning this lawsuit against Wilson are probably not much higher than a snowball's chance in hell. Not gonna happen. They're not gonna get $3 million. They're not gonna get Wilson to destroy their rackets. They're probably not gonna get anything at all. But before we go through this, let's just look at the brands. Here's the trademark that the band owns. The Clash, filed in February of 2008, registered in 2011. They got it for DVDs featuring live performances of a music band, downloadable musical sound recordings featuring music. All right, so that's Class 9, has nothing to do with tennis. Class 25, wristbands, short-sleeved or long-sleeved t-shirts, neckties, and sweatbands. So clothing, which is very limited to pretty much what a band would sell during live performances. But the fact is, they don't have any live performances because there is no band since 1986. So they may still have a store, an online store where this company, Durissimo, is selling some merch on their behalf. But again, the list is very limited. And then Class 41, entertainment in the nature of live performances by a musical band. It's interesting. So in theory, they're supposed to show that they're still using the brand every 10 years when they renew their trademark. So since the band had not been the band since 1986, how do you prove use of the trademark in association with entertainment in the nature of live performances by a musical band, right? So this is actually very interesting. I'm curious. So they filed a specimen into 2017. So let's see what they showed. That's their entire. So they got a T-shirt. I get that. And what is that? San Francisco. Yeah, let's see if I can open the PDF. Maybe I can make that bigger. Okay, so that's the shirt. Yeah, you can't really read this. Apparently, they're showing some use of the brand. I can't really read this. San Francisco Live Auditorium, and then some date and the time. Unfortunately, you can't read the date. So Let's see if they explain. Okay, so that's for class 9 or class 25. Internet grabbed screenshot of United States domestic concert poster. But they don't even mention what date, what year is this, right? So they're supposed to show use of a live performance in the US. And so, okay, they've got a screenshot of United States domestic concert poster, but they never mention which year it is. So, given that the band disbanded in 1986, I find it reckless on their behalf because they've opened up their trademark for being canceled for fraudulent renewal, for filing a fraudulent specimen of use or specimen. Even if it's not fraudulent, it doesn't really show use as of 2017. But let's keep going. So they had this trademark. So even in the best case scenario, it covers DVDs, live performances. None of this is what Wilson does. And they also covers wristbands and short sleeved and long sleeve shirts. So again, none of that is rackets. Now, and this is what Wilson has. They've got a trademark they filed in 2018, and it was registered in 2019, in August of 2019. So the band just missed the opposition when was the opposition? So the mark was published in September of 2018, and then it was allowed. So they forgot to oppose it, and here's what this one is registered for: bags specially adapted for sports equipment, tennis racket covers, and tennis rackets. None of this has anything to do with what the band owns as a trademark. Just because, again, some sporting events, even tennis sporting events, play their songs, doesn't mean that they now can claim that nobody can make products, tennis-related products, using the similar brand. It just doesn't make any sense at all, unless they can prove that their music is basically an anthem for all tennis-related games and events and championships. Short of that, this just won't cut it. This just won't cut it. And also, there's a couple more things that I wanted to show you. So they have just filed, the band has just filed another trademark in August of 2019. So pretty much as soon as the other one was registered, so pretty much as soon as Wilson's trademark was registered, the band filed another trademark, and this one is for tennis shoes, sneakers, jackets, sweatshirts, hoodies, zip-through hoodies, and sweaters. They're claiming use starting in 2006, and it's still class 25. So for the first time, they're going after footwear, tennis shoes, and they're specifically making reference to tennis, which is interesting. They've just filed this trademark. We don't know if it's going to go through, but I would say they would have a problem with at least some of the products here, because there's another trademark clash filed by Blower Manufacturing Company, Inc. In 2014 and registered in July of 2014. Wow, that was fast. From February to July. This is very quick. And so they have a trademark for work boots, namely tactical boots. So that's the same class 25. And the band's problem now is that they've got a trademark in class 25 for the Clash, and somebody else also has a trademark for Clash in the same class 25 for boots. So it's rare when the identical, virtually identical trademark is shared by several entities in the same class 25, unless there is a consent agreement, and I couldn't find one in here. So I guess the Trademarks Office made the decision that the band's list of goods and services is so limited, so specific, that the other company can be allowed to sell work boots. So again, they don't go for all footwear, but they go for work boots. And so now that there is this trademark for work boots, it's questionable that the band will ever be able to get the trademark for tennis shoes. I would say it would probably be precluded from getting that registered. Everything else they're probably going to get because of their prior trademark, but not the tennis shoes. And either way, even if they did get tennis shoes, it's class 25. It has nothing to do with tennis rackets or tennis bags. So I don't think that the band is going to get anywhere with this dispute except they lose and be forced to pay Wilson's attorneys fees as a result of losing the case. But that's essentially what the dispute is all about, and it's pretty interesting. It's pretty interesting because of all the layers of what's going on, but it also demonstrates how important it is to protect your brand, to trademark your brand in the right classes for the right goods and services, and to continually use it. Because if I were an attorney for Wilson, here's what I would do. I would immediately file paperwork in order to cancel the band's trademark. Because live performances, they probably can't prove it anymore. And DVDs, yeah, that will stay. Class 25, I'm probably gonna stay, but I would just go after class 41 for live performances, and that would probably lead to some sort of a settlement when one doesn't attack the other and the other doesn't attack the one. But we'll see where this goes. I'm sure this is going to generate some publicity, but it would be interesting to see, if there's a formal resolution to it, or both parties just settle quietly and things will go on as they always did. So I hope you found this video interesting. I hope you found it useful. I hope you learned something. And if you did, make sure you comment, like, and subscribe. Get notified whenever the next video goes live. And make sure you book your call with our strategy advisors if you've got a brand that you want to protect. The process works on our end in a way that you need to have a conversation with a live human being first. We need to understand your story. We need to understand the reasons why you want to protect your brand. What do you think is going to accomplish for you? And if we determine that we're the right fit, then we'll be able to get started with you and welcome you to the Trademark Factory family and help you protect your brand with the comprehensive trademark search, single flat fee that covers everything from start to finish, and 100% money back guarantee. So if you value those three things that I've just listed, you got really no option but to use Trademark Factory, because we're the only company in the world that offers this. So if you feel that your brand is worthy of being protected, book that call. And until then, I will see you in the next video.